All right, you guys, last week when the William McNeil traffic stop broke, I was actually in Florida. I had pre-recorded my videos so that I could just relax a little bit. And of course, Jacksonville has to do the dumbest thing, and the world had to find out about it while I was down there and wasn't in a position to say anything. And by the time I made it back, I felt like it had been pretty thoroughly covered, and I didn't have a lot to add. But after getting probably like 100 emails from my audience asking me to cover it, I found a few things that I thought could be worth mentioning. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. Now, just about everybody's familiar with this stop. It wasn't a great look for the Jacksonville PD. TK Waters has gone to great lengths, including releasing the body cam to just kind of act like everything's on the up and up. But there's a lot of problems with this traffic stop. For one, if you got Ben Crump in your city raising hell, having press conferences, something's wrong. Now, not everything that Crump does is something that I can get on board with. But what I am saying is that it's a pretty telltale sign that you've got some issues if Ben Crump is rallying in your city. So let's walk through the actual body cam. We'll talk about some of the things that have been mentioned and some things that haven't been mentioned. Lackluster did an incredible job of breaking this down, and I got a little guilty pleasure from watching him go at Brandon Tatum a little bit, and all of that's great and good. But there were a couple things that I thought could be mentioned from a legal perspective that I think will be relevant. So I found a way to be able to put my 2 cents in, hopefully in a way that you guys will appreciate. So let's take a look at the body cam. We'll stop along the way and we'll talk about some of the things that matter.
Yeah, Florida 24 Bravo Echo Charlie Whiskey on a silver Kia. I know like this.
Yes, sir.
Is there a reason why you're popping the door open like that?
I don't have a window that works. Is there a reason that you're pulling me over?
Yeah, absolutely. There's a reason why I'm pulling you over. For one thing, inclement weather, you don't have your lights on. 2 things, you're not wearing your seatbelt.
It's daylight.
3,
I don't need the lights. And it's not weather. It's not raining.
oh, this is inclement?
It's not raining.
Okay, I'm not arguing with you. I'm telling you why I'm pulling you over. Give me your driver's license, registration, proof of insurance.
No, call your supervisor. Why?
Excuse me?
Call your supervisor. Why did you pull me over?
77, 35. I'm a property driver. I've already told you.
Why did you pull me over?
Step out of the vehicle.
No.
Step out of the vehicle.
So first thing I want to talk about is right off the bat, we have to start, remember, don't crucify me. I'm going to say some things that's going to sound like cops-plaining. And what I want you guys to do is work really hard to not, every time that somebody says something that you don't want to hear, to automatically categorize it as cops-plaining. You need to know how the other side thinks, and you need to know how they build a case in order to understand what the strength of your rebuttal will be and what the gaps are in their case. And so in order to prevail against somebody else's persuasive presentation of the facts, you need to understand where their weaknesses are. And that's what we're going to do. So remember that under Terry versus Ohio, what matters is whether the officer had reasonable articulable suspicion of criminal activity, or in this case, a civil violation for not using headlights during inclement weather at the moment of the seizure. So at the moment that Mr. McNeil stops his vehicle, he is seized under the Fourth Amendment. Lackluster did an incredible job, as I mentioned before, in breaking down the actual statute. I think any objectively reasonable takeaway from the statute is that it mentions fog, rain, and smoke, and none of those things were in play at the time of the traffic stop. So I think it's fairly obvious from anybody that doesn't have a bias that there was not a traffic violation for Mr. McNeil not having his headlights on. I really don't think that's debatable from someone who's being intellectually honest. But the analysis doesn't stop there. You have to remember that in 2014, the Supreme Court of the United States took up a case called High versus North Carolina. And that case stood for lack of a more simple explanation, the fact that an officer can make a reasonable mistake of law and it still be ruled a justifiable reason to stop the vehicle. Okay, so remember the fact pattern in High is that High was stopped by a Surrey County, North Carolina sheriff's deputy for having a brake light that was not operable. Now, the officer interpreted North Carolina law at the time to mean that if you had your brake light out, it was a reason to stop the car. But the actual law in North Carolina only required that a person have one working brake light. And so Hyen was not actually in violation of the law at the time of the stop. Well, it turns out that Hyen had cocaine in his vehicle, and so whatever happened, the search, the court will always kind of find a way to do the mental gymnastics, sometimes to the extent that it looks like mental CrossFit, to try to justify a stop where there's some major evidence found. So, just like the Leon case, there was a lot of dope found in that case. If we're talking about a case where a body is going to be found, it really kind of depends on the evidence. And I know that's not fair, but sometimes it depends on what is actually at stake as to whether or not a court will invest a whole lot of time and energy into trying to justify the reasons for the stop. Well, we come away with Hyen understanding that a police officer can make a reasonable mistake of law and still be justified in the stop. So before we can just completely dispense with the idea that Jacksonville PD made a bad stop, we have to look at whether or not Hyen would apply. It was pretty well covered by Lackluster that the officers in question, as they responded, none of them had their lights on. But here's where I think Hyen fails. And here's what really matters. Remember that when I went back to Terry versus Ohio, I said it matters what the officer knew at the moment of the seizure. Well, the seizure was predicated on the officer performing a traffic stop. And what the officer knew at the moment of the traffic stop was that he wanted to stop that vehicle. Under Wren, pretext is fine so long as you have a lawful reason for the stop. We don't know what the pretext was, but we know there had to be pretext because the officer gets out and he says, the reason I stopped you is because you don't have your headlights on during inclement weather. Lackluster covered this. This part isn't what was missed. As the backup officers come along to provide backup, none of them are using their headlights, and that's all well and good. None of them were present at the time that the police officer made the seizure. Remember, it's what he knew at the time of the seizure. Well, look here. As the officer diverts his attention back towards his cruiser, you can see that not even this police officer was using his headlights at the time that he stopped Mr. McNeil. No windshield wipers are visible when we're getting out from the body cam. No indication that the officer himself is seeing this weather as inclement weather to the extent that he feels like he's obligated to use his own headlights or use his own windshield wipers. To me, that negates any claim that would exist under a Hyen analysis because no reasonable police officer would interpret the law to mean that lights were to be used if they weren't using them themselves. And so it kills the Hyen analysis. And so now we have a pretty universally understood bad traffic stop. Okay, but that's not really what everybody took notice of. It was the punch. It was the punch that after the window was broken that everybody was focused on. And I get it. That's the worst part of this traffic stop. But before we can get to a place where we can convict these guys of busting the Constitution, we have to walk through the analysis and prove our case. Remember that it's the person who brings the suit. It's the person that brings the case that has the burden of proof to try to make the court understand what went wrong. And we have to walk through that in order to get there. Okay, so we've gotten past Terry. We don't have a traffic violation. We've gotten past Hyen because we don't have a reasonable mistake because the officer wasn't even using lights or windshield wipers himself. So there's no reasonable officer that would have expected this person to do it. We can get past any notion that the officer thought that he wasn't wearing a seatbelt because we hear the officer on body cam saying that he can't see inside the vehicle. He doesn't know how many people were in there. So we know for sure that there was no observable violation as far as seatbelt. It was daylight. Roads might have been wet, but there's nothing about the statute that says anything about overcast conditions or whatever. And if you've ever been to Florida, you know that it rains almost every day. So if you're going to make the rule that you have to use your headlights after the rain, you're going to have to use your headlights all the time. And we know that's not reasonable. So then we have to look at the resisting without violence statute. Remember that in Florida, they have this wacky resisting without violence charge that they always arrest Jeff Gray for, and he never gets convicted of. Because what they want to be able to do is arrest a person anytime they defy a lawful order being the operative part of that, from a police officer. So if a police officer gives you a command to get out of the vehicle under MIMS, which is what essentially was happening in this McNeil case, again, if you don't get out, assuming the lawfulness of the stop is on point, then you're probably guilty under Florida law of resisting without violence. So we need to figure out what Florida case law says about whether or not a person can be convicted of resisting without violence where the original stop was unlawful, right? So we got past Terry versus Ohio. We don't have a good stop there. We got past High-End. We don't have an objectively reasonable mistake of law here because the officer didn't use his own headlights. And so now we're on to, okay, what are the ramifications for not following a police officer's order when the stop was unlawful in the first place? And that's where the resisting without violence kind of fails too. Because under a 1996 case called Espinoza, which was a Florida Supreme Court case, the court ruled that you can't be convicted of resisting where the original stop was unlawful. So in Espinoza, the Florida Supreme Court interpreted Florida's resisting without violence statute, which is 843.02, as not applying to situations where you do not have an underlying lawful arrest to begin with. And in the context of this one, we're talking about the traffic stop itself. In addition to Espinoza, we have some 11th Circuit precedent from 2005 from a case that came out of the 11th Federal Circuit, which is where Florida is situated. The case is Thornton versus City of Macon, which is obviously Macon, Georgia, and it's an unpublished but still persuasive 11th Circuit opinion that says that if the initial arrest is unlawful, a conviction for resisting may not stand if it depends on that unlawful arrest. And again, all of this is predicated upon the lawfulness of the original stop. So in my opinion, there's Florida Supreme Court case law and 11th Circuit case law that stands for the proposition that a police officer can't give you an order that would then be the predicate for a conviction for resisting without violence. So in my opinion, this is not a situation where he could have been convicted of resisting without violence. So that causes us to move on to the next part of the analysis, which is going to carry us into sort of a Graham analysis. What I want you to pay attention to, we're going to review the window break itself. I want you to pay attention to what the officer's cadence and his voice sounded like as he was telling him, I'm going to break the window if you don't get out, and waiting for other officers to arrive. And then once the officers arrived, I want you to notice how his voice changes as he gets ready to bust the window.
Open the door and exit. You are under arrest for resisting. Open the door and exit. You are under arrest for resisting. Hey, I'm about to break the window.
Can you call the supervisor?
All right, go for it. Exit the vehicle now. Exit the vehicle. Show me your hands.
Here.
1033 at 16:21 hours.
Notice that the officer's voice was, in my opinion, filled with anger or rage or whatever. He lost his temper, but he waited till backup arrived. And then he started giving much more escalated commands after backup arrived, all without their headlights, by the way, but after they arrived nonetheless. So what we're looking at is a person who lost their temper. And that's where I think this really crosses the line as far as the Graham analysis, because
What is your reason? Step out. What is your reason? Step out now. No, don't fuck it. Give up the crash.
Put your hands behind your back.
I'm resisting.
Hands behind your back.
What's wrong with you? What you mean? I was putting my hands behind my back. I was on.
Ain't no talking now, man. Ain't no talking.
Fucking talking shit, bro. I'm doing, bro. What's going on, man?
You're under arrest. That's what's
No,
going
bro,
on.
no, bro.
Yes, bro.
Yes.
Yes.
No for reason, bro. I'm gonna on the phone like that, bro.
Yeah, I'm gonna take it off
now,
of you,
man.
bro.
And I'm just trying to have a regular conversation with y'all, bro. Too late.
You just gotta see what the already.
So your partner didn't even ask.
Marijuana in his right pocket.
Yes, it is.
So why close the door if you see him pull up?
Because, man, what you mean? He talking about arresting me and stuff, bro. I didn't do nothing
It's
wrong.
called resisting, idiot.
I didn't do nothing wrong, bro.
I mean, breaking the window under the circumstances was excessive force because they didn't have a lawful reason to stop. They didn't have a lawful reason to demand that he get out because the stop wasn't lawful. And then they didn't have a lawful reason to arrest him or place him under arrest. Remember that the officer said beforehand, you're under arrest for resisting. So the whole predicate for busting the window was this unlawful arrest that was born out of an unlawful command that was first tethered to an unlawful stop. So we got no lawful stop. We got no lawful request for ID. We got no lawful command to get out. And we got no lawful arrest for resisting. And so then we got no lawful SELA related to the dope or the knife, which wasn't illegal in the first place. So they literally have nothing. The biggest mistake that was made in the process of this was, I don't know, I assume that Mr. McNeil had counsel. I assume it was probably like a public defender or court-appointed counsel, and somebody somewhere negotiated a plea for him that was not in his best interest, because the problem with the 1983 analysis is that he pled guilty to the resisting without violence, and he pled guilty to driving on suspended. Now, driving on suspended doesn't really have any sort of bearing on the 1983 analysis, because it's something that was sort of ancillary to the stop. Pleading guilty to that doesn't make a difference. But pleading guilty to resisting says that their actions in order to take you under arrest for resisting may have been justified. It's generally a bar. Now, your 1983 claim could still move forward on excessive force, and so that's what we'll talk about now. If you think about the Graham factors, the force has to be proportional to the threat, for one, and it has to be reasonable in scope to sort of accomplishing what you're trying to accomplish. Well, take a look here. You get 2 punches initially by the police officer. It doesn't break the window. And here's the second one. It breaks the window. There's a period of time, albeit brief, where the officer knows that the window is broken. There is no reason for this third strike that comes through the window, except that he wanted to punch Mr. McNeil in the face. There is nothing else. There's no justification. It's obvious that the officer lost his temper. And that's where you journey into the unreasonableness of this use of force. There was nothing about that use of force that was going to accomplish a lawful objective, even if you assume that the arrest was lawful. Because remember, in order for the courts to figure out whether or not force was proportional, they first assume that the arrest was lawful. And then they say, okay, in the process of accomplishing this lawful arrest for a person who's resisting without violence, what did this punch, the third strike into the window after it had been broken, accomplish as far as making a lawful arrest for resisting without violence? And the answer is nothing. It didn't do anything. And it also led to what I think is actually the most heartbreaking part of this whole thing. And it's so hard to watch, because if you look at Mr. McNeil's face, it's the face of a person who is completely helpless. It's very difficult for me to watch this, because what I see in Mr. McNeil's face is a broken spirit of a person who feels like they need to fight, feels like they want to stand for something, but feels completely helpless in doing that. Because I can see in his face that he believes that if he does anything other than sit there, that he will probably be killed or hurt beyond measure. And so it's just hard to watch a human being have their spirit broken right in front of your face. If you have a heart, it is. And I have a heart. And to be honest with you, I'm a little bit soft when it comes to this type of stuff, because I hate to watch a person's spirit be broken. There's no reason for it. It wasn't even a lawful traffic stop. And it was devastating to me to just watch this guy who otherwise held his head high have his spirit broken right in front of our eyes. And I think, to me, that's the most devastating part of this whole thing, is not the punch. He's probably been punched in the face before. Most of us have. It's being punched in the face and feeling like you cannot do anything about it. Feeling helpless in a situation where you should be able to rely on the reasonableness and the protection of the people that you're dealing with is the hardest part of this to watch, in my opinion. That leads us to, now that we know that the force was likely excessive, because he wasn't presenting a threat at any point, actually. Any threat that might have existed wasn't found out until after they got the car open. So the knife, they made a big deal about it because they wanted to justify what they did, but there was no big deal. There's no law that says you can't have a knife in a car. There's nothing there. The marijuana would be fine if the arrest for resisting was lawful, but the arrest for resisting wasn't lawful. So you don't have search incident to a lawful arrest. I don't know whether they towed the car. I assume they towed the car. They might have been able to find that stuff on an inventory search, but we don't have any mention of that. And what I think really tells us a lot about what we don't know is how the state negotiated this in order to get a conviction. Notice that we talked about how the court will do mental gymnastics and work all the way around an issue just to come back to justify it if there's evidence they don't want to suppress. Well, probably the most severe thing that happened in this whole case was the marijuana. He didn't plead guilty to the marijuana. That tells me that the state knew that that would not survive a suppression motion. And in order for the state to be in a situation where they thought, I'm going to lose this marijuana evidence, that means that the state knew that the resisting without violence was probably an unlawful arrest. So for whatever reason, Mr. McNeil pleads guilty to resisting without violence, and all the rest of this stuff gets dismissed. He pled guilty to driving unsuspended, and he pled guilty to resisting without violence. And unless he can get that conviction overturned, that resisting without violence will probably negate any 1983 claim for false arrest for that part of it. Now, he can still survive a 1983 claim for unlawful seizure for the original traffic stop, and he can still present a 1983 claim for excessive force. But unless he can get the conviction overturned, he's not going to be able to work through an unlawful arrest for the resisting without violence because he pled guilty to it. Well, is it possible for him to get the conviction overturned? And the answer is yes. Under Florida's rules of criminal procedure, there's a 2-year window where you can present whatever the standard is for the evidence in order for the court to vacate or set aside the conviction. And so because of the fact this was a guilty plea, and because of the fact that he's now represented by counsel that want to proceed on all of the claims they can muster under a 1983, then of course they will be able to motion the court to try to set that aside. Whether or not they prevail as far as getting it set aside, it's hard to say. But the point is they can make the motion to the court. And I think this case is going to get settled because, look, you still have a 1983 claim under unlawful seizure for the original stop and under excessive force. Both of those are Fourth Amendment violations. You don't necessarily need the third count for the unlawful arrest under the resisting without violence in order to get a big check on behalf of Mr. McNeil for the civil rights violations. But still, they're going to try to get that conviction vacated because it strengthens their position in court either way. In closing, the only thing that I want to say as far as Mr. McNeil goes is that it is incumbent upon me to explain to my audience that you do not have a constitutional right that is tethered to your ability to have a mediator come along in the form of a supervisor and stand in judgment of his officer on the side of the road. You don't hold court on the side of the road. You do certain things in order to preserve your rights. You say, what's going to happen to me if I don't do this, right? You ask one question and they say, we're going to arrest you or whatever. If I don't do it, what will happen? You get all of this under threat of arrest and then you don't have this. Now, if you do that, then, sometimes I'm in the closing argument saying, well, he didn't really have any damages because he didn't get his ass beat. So, look, if you want damages, this is the way you do it. The problem is the risk versus reward calculation really starts to rear its ugly head because, this could have been a situation where the guy died, right? This could have gotten way, way uglier. This was a scenario where all of the boxes are checked as far as unlawful stop, excessive force, unlawful arrest. All of those things are there. We didn't actually need the damages, but they will. They're the reason Ben Crump's there, right? That punch heard around the world. That punch coming through the window and being seen right there. Thank goodness that Mr. McNeil did do the thing that we always say to do, which is always record your interactions with the police, right? But the arguing and the demanding supervisors, you don't have a constitutional right to someone's supervisor. These are things that you address later. And, it's not my job to tell people what is worth living or dying for. That's not why I'm here. I just want to put the information out here that, look, you don't have a right to a supervisor. Most states do not require the police to tell you basically anything. Their policy might, but the law doesn't. So please just keep that in mind as you're making these decisions and deciding which hill you're going to die on. And I do mean that sometimes this is the hill you might die on when you're making these decisions. So that's it. That's my analysis. I think absolutely the state signaled their understanding that this was a bad case in the way that they negotiated the plea. And I think ultimately this will probably get overturned as far as his conviction because, again, based on the case law that we talked about. But this is my take. Hopefully you guys got something from it. I'll probably write a follow-up blog over on Substack or mention it in some way. Somebody will bring up something in the comments. Substack is a newsletter. It's absolutely free to join. I'd invite you to come over and check out our community there. You can join on a paid tier if you want to, but it's not required. It's only for people who want to support the channel monetarily. I don't put anything on Substack that people have to pay for. If you don't want to go to Substack, but you'd still like to support monetarily, I'll put my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police to keep your evidence to yourself.